Here.
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 All right, and we've currently have 2 vacancies and 2 folks who couldn't be here today. So that's why there's a limited number of us, but we still have a quorum, so we can proceed. Let's begin by saying the Pledge of Allegiance. I pledge allegiance
To the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, item number 3 on the public session agenda is consideration of the January 26, 2024 public session minutes. Oh, I guess I should start with preliminary announcements that I skipped right over. So the First District Court of Appeals graciously lets us use these facilities, so please respect the rules and have absolutely no food or beverage other than water in this room, and silence your cell phones. We've received some feedback from the public that it's sometimes difficult to hear the members and those before the commission, and I'm extremely guilty of that. That's true both in this room and over live stream. So anyone addressing the commission and to the members, please make sure to speak up and speak into the long microphone at the podium so you can be heard, and so our broadcast audio recording equipment can pick up your comments. Same to the commission members, speak into the long microphone so your comments and debate can be heard. Members, I ask you be as brief and concise as possible in your questions and comments, as we have a number of items to consider today. Pursuant to Section 286.0114 of the Florida statutes, members of the public have the opportunity to have input on matters before the commission other than in cases in which we act in a quasi-judicial capacity. This means the public can have input on matters other than complaints, opinions, and determinations in financial disclosure cases. If you desire to be heard on a matter, please fill out a speaker card and give it to Ms. Clifford, who has her hand up. All right, so now we can go to approval of the public session meeting minutes from January 26, 2024. Is there a motion to approve the minutes?
So moved.
Second. All in favor?
Aye.
All right, item number 4 is consideration of final action on a stipulation in re Brian Mulligan, 21-101. Will the parties or their counsel please identify themselves for the record?
Elizabeth Miller, advocate for the commission.
Good morning, Ms. Miller.
Good morning, commissioners.
Probable cause was previously found in this complaint, and now we have before us a joint stipulation between the commission advocate and the respondent. After considering all of the materials and the presentation of the parties, the commission may vote to approve or to reject the stipulation. Stipulations rejected, the parties cannot renegotiate and present a new stipulation at this meeting. The complaint would go to the Division of Administrative Hearings for an evidentiary hearing, or the parties could negotiate a new settlement for consideration at another commission meeting. Complainants have the right to respond in writing to proposed stipulations. We have not received any comment from the complainant in this case. Are there any members of the commission who need to make a disclosure regarding this case? All right, Ms. Miller, you're recognized.
Thank you. The respondent served as the battalion chief for the Palm Beach County Fire and Rescue. He retired in May of 2021. He trained and mentored employees to take the captain's test. The violation is that he used the facilities of the county to do so. The investigation focused on 4 employees. The respondent earned $9,500 plus about $3,000 in pool renovations from the 4 employees. We went to mediation, and what you have before you is the result of the mediation. The respondent admitted violating the misuse of public position statute and admitted that he had a conflict of interest. He agreed to pay $1,000 per allegation for a total of $2,000. We respectfully ask that you adopt the agreement. Thank you.
Thank you, Ms. Miller. Are there any questions from the members for Ms. Miller? Is there a motion to adopt the stipulation?
Motion.
Is there a second?
Second.
Any debate? All in favor?
Aye.
All right, and the stipulation is adopted. Thank you. All right, item 4B, as in re Stephanie Busen, consolidated case numbers 22-178 and 22-185. Will the parties or councils identify themselves for the record?
Elizabeth Miller, advocate for the commission.
Is there no one else? All right, Ms. Miller, you can present the stipulation.
Thank you. The respondent is a member of the Hendry County School Board. She was invited to talk to a third grade class about the election process, and she used this as an opportunity to speak about her election and to distribute campaign materials to the children. Prior to the commission's investigation, the Hendry County School Board admonished respondent for her activity. In the stipulation, respondent admitted to the violations and agreed to pay $1,500 per violation for a total of $3,000, along with a public censure and reprimand. We ask that you adopt the stipulation. Thank you.
Thank you. Are there any questions on this item for Ms. Miller?
Yeah, I have a question. Good morning.
Good morning.
I'm just curious with respect to the civil penalties levied here versus, let's say, the prior case. How do we arrive at the $1,500 versus the $1,000? I mean, what's the thought process that goes there?
Through the chair, the first mediation involved a judge who believed that the offense was not quite as egregious as some that he's seen, due to the fact that the respondent was using the downtime of the firefighters to train them to be better in their positions and to enhance or be promoted in their positions. He thought that that was a good use of time, and that was a stipulation as far as mediation went. The second one was not mediated. That was between the parties, and that's what she agreed to. Her offense or offenses were more personal to her, and she was campaigning for re-election, whereas she was not helping someone, she was giving and getting more of a benefit than in the first case that you saw.
I remember that case. I remember that. We had a lengthy discussion on that case. Okay, that's fine. Thank you.
Okay, thank you.
Are there any other questions? Is there a motion to adopt the stipulation?
Move the advocate's recommendation.
All right, is there a second?
Second.
Thank you.
All in favor?
Aye.
All opposed? Thank you. Okay, moving on to item number 5, consideration of final action, joint stipulation for willful failure to file financial disclosure. The first item, under item 5 is in re Mark Cagney, case number 21-238. Is respondent or their counsel in attendance? Probable cause was previously found in this matter, wherein the commission undertook a statutorily required investigation to determine if the respondent's failure to file his Form 1 was willful. Now we have before us a proposed joint stipulation between the commission advocate and the respondent. After considering all the materials and the presentations of the parties, the commission may vote to approve or reject the stipulation. If you reject the stipulation, the complaint would go to the Division of Administrative Hearings. Parties cannot renegotiate and present a new stipulation at this meeting, nor can the commission negotiate a new stipulation. Before the advocate presents the stipulation, does anyone have any disclosures in this matter? All right, Ms. Miller, go ahead and present the stipulation.
Thank you. Commissioners, this respondent failed to file his 2018 CE Form 1. When a violation of a willful failure to file is found, the only penalty available is removal from office. And this respondent did violate the statute. He agreed to be removed from office. And I ask that you adopt this recommendation, or this stipulation, excuse me.
Are there any questions from the members on this stipulation? I have a question, Ms. Miller. Why not just resign? I guess what I'm struggling with is if you're stipulating to removal from office, why not just resign from office?
I don't have the answer to that, other than I believe his tenure is soon to be up. I'm not absolutely certain of that, but I do know that he isn't real interested in serving on this board anymore, and he did agree to a stipulation. I don't know why he doesn't resign.
So when we approve the stipulation, can he continue serving until this is imposed by the governor?
That's correct. Yes, ma'am.
Okay. Yeah. Sure, go ahead.
Thank you. I can provide a little more information on that. I don't know the gentleman, but it's from my area, Clearwater. They're currently, they just had elections, primary elections. They're an off-year type election. And I think this is one of the seats that someone's seeking. So she's right. Once it runs its culmination, then a new person will be there anyway. So now I was going to ask you how much time he had left, but you got into that. But yeah, Clearwater's running their elections. I think it was this week, if I wasn't mistaken. So.
Are there any other questions, any discussion? Is there a motion to adopt this stipulation?
I move the approval of the joint stipulation.
Second.
All in favor?
Aye.
Aye.
All opposed? Okay. All right, the next willful failure to file joint stipulation is in re Angela Huff, case number 22-012. Is the respondent or counsel in attendance for this one? No. Does anyone need to make a disclosure in this matter? All right, go ahead, Ms. Miller.
Thank you. This respondent is a member of the Moore Haven Mosquito Control District for the city of Moore Haven. It's the same situation. She willfully failed or refused to file her 2018 CE Form 1 Statement of Financial Interest. She has agreed to the only penalty available in such situations, and that is removal from office. I respectfully ask that you adopt the stipulation. Thank you.
Question, Madam Chair. Do you know how much time she has left?
I do not. I'm sorry.
Thank you.
Are there any other questions from the members? Is there a motion?
I move the approval of the joint stipulation.
Is there a second?
Second.
All in favor?
Aye.
Aye.
All opposed? All right, thank you, Ms. Miller. Let's see, so the item number 6, in re Henry Rosenthal, this was continued until the April meeting. I granted the respondent's continuance request on Tuesday, so we will jump to item number 7, consideration of probable cause. This is the probable cause hearing of complaint number 23-231 in re Jonathan L. Owens. The respondent, complainant, or their counsel in attendance. Okay, could you please state your names for the record?
Dennis Green, attorney for Jonathan Owens.
Thank y'all for being here. The probable cause determination is the conclusion of the preliminary investigation. The respondent and the advocate are permitted to make brief statements in the nature of oral argument to the commission based on the investigator's report, the advocate's recommendation, the complaint, and staff recommendations, as well as any written statements submitted by the respondent. No testimony or other evidence will be accepted at this hearing. This hearing is being not conducted in a closed executive session. That's okay. Probable cause is found today. The respondent will have the opportunity to request a full evidentiary hearing before an administrative law judge at the Division of Administrative Hearing. The advocate and the respondent will have 10 minutes. The commission advocate will present the probable cause recommendation first, and then we'll hear from the respondent. If the advocate reserves time for rebuttal, that will be allowed. Are there any members who need to make a disclosure? And I guess we'll just note, since this is a probable cause hearing, that Mr. Owens consented to or waived the right for this to occur in the executive session, which is why it's being heard in public session. Go ahead, Ms. Miller.
Thank you. I'd like to reserve any remaining time, please.
Sure.
The complainant is the Escambia County Commissioner, Mr. Burgash. Respondent served as a full-time legislative aide to another county commissioner in Escambia County. Respondent and County Commissioner Burgash have had a contentious relationship throughout Commissioner Burgash's tenure on the commission. In fact, respondent unsuccessfully ran against Commissioner Burgash for the seat that he currently holds. Commissioner Burgash uses his personal cell phone for personal business and for public business. He was having problems with his phone, so he took a thumb drive to the IT staff in the county and asked them to transmit that information onto the thumb drive. He directed staff to make one copy and not make or retain any copies of his private phone calls or phone messages. An anonymous source left a copy of the thumb drive on respondent's desk in his county office. On the thumb drive were personal, privileged information that Commissioner Burgash had put on there, including confidential medical information, family medical information, personal financial information, including Social Security numbers, attorney-client privileged information, and personal text messages between Commissioner Burgash and his family members, his friends, and his associates. Commissioner Burgash did not authorize anyone to have a copy of this thumb drive or of his messages. And the statutes say that a current or former employee may not disclose or use confidential information acquired in the course of his official duties for his personal gain or the gain or benefit of others. So what exactly was the benefit here? The respondent disseminated this information to a purported friend of his, to a media company that owns the local newspaper, the Pensacola News Journal, and to a law firm that is representing a former employee who is currently suing the county of Escambia County. So who benefited? Certainly we know that the county employee and her attorneys benefited. We know that because respondent admitted as much. He said that he gave the information to her attorneys, and I quote, because he thought it would be helpful, end quote. He also may have benefited himself because the text messages involve personal, private, privileged, and confidential communications between Commissioner Burgash and his family members, attorneys, personal confidants, and business associates. Should respondent choose to run against Commissioner Burgash again, he may use this information against him. If not, he could otherwise give the information to someone else who seeks to defeat Commissioner Burgash in the 2024 election. All elements to prove a violation have been met. Therefore, I respectfully ask that you find probable cause. Thank you.
Thank you.
I have a question. Thank you. You didn't mention anything about, you mentioned medical records and you mentioned other communications. You didn't mention anything about HIPAA law violations or sunshine, because if that information was on there, it's medical, and you'll only be able to release unless you sign something, to omit someone from HIPAA so they can share your medical information. Was there any problems with that in the case?
Through the chair, there is a criminal case being investigated now, and there is also a lawsuit. So I'm sure that will come out during one of those two things.
Okay. Thank you, Ms. Madam Chair.
Thank you.
Mr. Owens, Mr. Green.
Good morning. I find it ironic that what's at heart here are these cell phone messages, the text messages, the data that was collected. And what's ironic is there's currently a criminal investigation against Commissioner Burgash, who's a suspect of violating sunshine law involving communications contained in that cell phone data.
This is outside the report of investigation.
But today, we are here to discuss probable cause against my client for this alleged offense. Probable cause is more than just a mere hunch, suspicion, You know, I think maybe, I don't know, but potentially, probable cause requires evidence. Now here, what are the elements that must be proved? One, Mr. Owens was a county employee. Number two, Mr. Owens obtained the cell phone data in the course of his official duties, through his official position. Four, that the information was privileged or not available to the public. And finally, that it conferred a benefit on someone. It's not in dispute that he was a county employee when he came into possession of the cell phone data. But what is in contention, I find it very interesting, is in this report, not one single analysis was done on how he obtained the data through his official position as a commissioner's aide. He didn't work in the IT department. He wasn't entrusted with it. He was not a custodian of the documents, anything like that. He simply came to work. I don't know how they can overcome that hurdle, but certainly they're drawing a lot of conclusions here. His job duties didn't have anything to do with Commissioner Burgash's cell data. His access that he had at the county didn't even give him access to the county server, so he couldn't have even logged onto a computer to go and get this information. This statute right here involves primarily procurement. Hey, you're working at the county, there's a request for a proposal goes out for, we're gonna have a paving job, and you get these sealed bids in, you call your brother-in-law up and you go, hey, guess what? Here's where your bid needs to be, and you can get this job. That's what this statute's for. Here, there's nothing to support that Mr. Owens used his official position to acquire the data. As a matter of fact, I would direct you to page 4 down at the bottom and read what it says. The county's Office of Compliance and Ethics investigation was unable to provide any conclusive findings as to how respondent obtained the cell phone data. She says it right there in her own report. Well, now it's a problem. There's not one shred of evidence to support that element. Therefore, the entire case fails. But looking at the other parts of the elements, regarding information not available to the public, here you have a trove of data. And within that data, the information that was used by Dr. Edler's attorneys in her lawsuit are all of public importance. As a matter of fact, these documents were inspected in camera by a federal judge. The federal judge determined which pieces of evidence were going to come into that case.
Objection, excuse me for interrupting. This is all outside the report of investigation.
In the
Or it's not admissible.
That judge made a determination that certain parts of that cell phone data could come into evidence. And I would also tell you that the cell phone data is also subject to public records and sunshine law. He's the one using his personal phone for county business, commingling everything. And for that right there, it fails. Also, what conferred benefit? Any conferred benefit on Dr. Edler was from documents that are readily available or would have been readily available or covered under sunshine while Mr. Owens was an employee, but he didn't obtain them through his official position. Furthermore, the state would like you to believe that they have the opportunity and the ability to be clairvoyant and determine what the future is, that he may get a benefit. It's possible he could give it to somebody else. Well, that's not what the statute says. Statute doesn't say an intent. The statute says gained a benefit, gained, took possession of it, gained a benefit. Here, you can't sit here and say Mr. Owens gained a benefit for running in the future, or maybe somebody else running against Commissioner Burgash. So I think this whole case fails right there on that. He didn't gain it from his position as a commissioner's aide. The documents that were used in Dr. Edler's case are certainly subject to the Sunshine Law. 3, you can't say he conferred a benefit upon himself or something in the future has never occurred. So I'm asking you today to use some common sense and find that probable cause does not exist in this matter. Furthermore, there's not one shred of evidence linking my client to the disclosure to the Pensacola News Journal or his supposed friend. Again, more conclusory statements coming from the state. Thank you for your time and consideration.
Any questions?
Sure, Mr. Green will probably have some questions for you. Go ahead, Commissioner.
Thank you, and thank you guys for making the trip up here. I'm going to try to keep it inside the boundaries of why we're here. I know you went all over the place for a lot of other stuff, but I don't want to put too much out because people watching the Florida channel may be participating in that lawsuit. That's for you and your client. You said something at the end about benefit, or you said he benefit of gaining possession of. So I'm curious of if he gained possession of his information, and you said it wasn't a benefit being a public officer, but for the public trust and making him a commissioner, he wouldn't have had been anywhere near this information because it happened, I think, in the confines of the commission officers, if I'm not mistaken. That's what I'm reading. So
Sure.
what do you mean by
the state's position is that, hey, he should have turned the documents, the cell phone data, back over to the county. Well, there's 2 problems with that. One is obviously First Amendment issue. Okay, there's issues and things contained in that data that are of significant public importance. Number 2, he didn't get it because of his official position of working there at the attorney's, at the county's office. And furthermore, what the state's saying is, hey, you discovered some potential sunshine violations, so here, go give it back to the suspect. I mean, it doesn't work like
All right.
that.
Madam Chair, if you let me finish, I was trying to get to that point. How many commissioners are there within commission officers or commissioners on this commission?
5.
5. And did any other commissioner have thumb drives on their desks or have access to this stuff other than your client?
I have no idea.
Thank you, Madam Chair.
Are there any other questions for Mr. Green?
Yes. Mr. Green, thank you as well for your presentation. I was snagged on your comment that this information was available to the public, but there's some information that would not have been available to the public given that it was privileged or private, confidential information. So it's true that a portion of it might have been available, but not all of it, and all of it is what was disclosed. Is that correct?
Yes, ma'am.
Thanks.
Are there any other questions for Mr. Green? Thank you. Ms. Miller?
Thank you. I'll be brief. First of all, it is not my position that he should have turned the information over to the county. It's my position that he should not have disclosed the information. And as far as the statute being for procurement, I am unaware that any case law says that, or the statute doesn't reference that specifically, so I disagree with that statement. And how was this information obtained? Someone left a thumb drive on his desk at work in his county office, but for his position, he would not have acquired this information. I ask that you find probable cause. Thank you.
Any questions or discussion from the members? Is there a motion on whether or not to adopt the advocate's recommendation of a finding of probable cause?
I move the adoption of the advocate's recommendation.
Second.
All in favor?
Aye.
All opposed? Great. Mr. Owens, Mr. Green, thank you for being here. Thank you for your argument. All right, moving on to item number 8 of the agenda, consideration of a couple advisory opinions. Is there any public officer, candidate for public office, or public employee in Florida who's in doubt about the applicability of the disclosure laws or standards of conduct to himself or herself, or anyone who has the power to hire or terminate another public employee may seek an advisory opinion from this commission about himself, herself, or that employee? Advisory opinions are based solely on the facts provided by the requester and are legally binding on the conduct at issue. Is the requester in file 2810 here?
He is not in attendance.
Okay, all right, go ahead.
Thank you, Madam Chair.
Thank you.
This opinion comes to us from Lonnie Groot in Daytona Beach, who is an attorney associated with firms that have been hired to perform legal services for various cities. Mr. Groot performs some of the legal work for 3 of those cities. Mr. Groot asks whether his being associated with a firm that has been hired to provide legal services to a city, or whether his serving as a local government special magistrate/hearing officer requires him to file a CE Form 1 Statement of Financial Interests. Mr. Groot performs legal services for the cities through 2 firms. He performs legal services for Sanford and Lady Lake as an independent contractor in an of-counsel relationship with Sternstrom, McIntosh, Colbert, and Wiggum, which I'll refer to as Sternstrom. And he performs legal services for the city of DeLand as an independent contractor, again, in an of-counsel relationship with Paul Elkine, Brands, and Paul, which I'll refer to as Paul. He also serves as a special magistrate, also known as a hearing officer, for the city of Cocoa Beach, and he's seeking to become a special magistrate hearing officer for Flagler County. With regards to the Stenstrom firm's representation of Sanford, an attorney other than Mr. Groot in the firm is regarded to be Sanford's city attorney. Mr. Groot only attends Sanford Commission meetings if the person regarded as a city attorney can't. Mr. Groot attends most of the board meetings for Sanford's Planning and Zoning Commission and its Historic Preservation Board, and he handles routine tasks related to the city, like drafting documents. With regards to the town of Lady Lake, Mr. Groot serves as legal counsel for the town's arbitration panel only. With regard to the Paul firm's representation of DeLand, again, an attorney other than Mr. Groot is regarded as the city attorney for DeLand. Mr. Groot has covered some city commission meetings in the city attorney's absence, and he's handled some ad hoc projects, but the person regarded as the city attorney performs the bulk of the work for DeLand. Mr. Groot also has not worked for the firm or the city in approximately a year, but he remains under contract. As stated above, then, Mr. Groot's a special magistrate for the city of Cocoa Beach. He submitted a resignation for that position effective the end of this month, and he's seeking to become a special magistrate/hearing officer for Flagler County. As to the law, one of the requirements in Section 112.3145 Florida statutes, which pertains to financial disclosure, is that local officers must file a CE Form 1 Statement of Financial Interests. Municipal attorneys are included in the list of local officers that are required to file a CE Form 1. When it comes to the requirement that municipal or city attorneys have to file CE Form 1s, the Commission stated in CEO, or Commission's opinion, 08-27, that the statute does not differentiate between a city attorney who is a city officer or employee, an attorney retained via contract in his individual capacity, or an attorney whose firm has been hired via contract, if that attorney does the majority of the city's work for the firm. In CEO 77-138, the Commission found that the fact that a city attorney is hired as an independent contractor does not relieve him or her from the obligation to file a CE Form 1. In CEO 77-138, the Commission found an attorney engaged in private practice to be a public officer required to file financial disclosure since he had been retained as the city attorney. In CEO 19-15, the Commission said that a private attorney who routinely provided legal services to a town and who rendered more legal services to the town than any other attorney would be considered a local officer for purposes of Section 112.3145, and thus would be required to file an annual statement of financial interest, even though he had no ongoing contractual obligation to serve as the town's attorney. In summary, the requirement to file a CE Form 1 applies to anyone who holds the position of municipal attorney or who routinely serves as the attorney for a city or town, who renders more legal services to the city than any other attorney, and who is recognized to be the city attorney regardless of whether they are employed by a municipality, an independent contractor of a municipality, or they're part of a firm hired by a municipality. In Mr. Groot's case, he's not the person who is recognized as the city attorney for any of these cities, and he's not the person who renders more legal services to the cities than any other attorney. Other persons in the firms are regarded as the city attorneys for those cities, and they perform the majority of the legal services for them. The work Mr. Groot performs for the cities is on a much lesser scale. He attends city commission meetings in the city attorney's absence, performs routine tasks like drafting documents, attends meetings of some of the subordinate boards, and he's handled some ad hoc projects. In that Mr. Groot is not regarded as the city attorney for any of these cities and does not do the majority of the legal work for the cities, he would not be considered to be a municipal attorney for purposes of Section 112.3145, subsection 1A3, and thus would not be required to file a CE Form 1. Now, with regard to whether Mr. Groot would be required to file a CE Form 1 by virtue of being a special magistrate / hearing officer for a city or county, the only hearing officers mentioned in the statute, Section 112.3145, that are required to file CE Form 1s are those who are state employees, such as persons who are hearing officers for state agencies. In that Mr. Groot is a hearing officer for a city, and the hearing officer position he is seeking is that of with a county, he would not be required to file a CE Form 1. In conclusion, Mr. Groot would not be required to file a CE Form 1 under these circumstances. I present this draft opinion for your consideration, and I'm available to answer any questions.
Thank you, Ms. Hayward. Are there any questions? Is there a motion?
Take a motion. Make the motion to adopt.
Okay, all in favor? Thank you for the second. Sorry, all in favor? Aye.
You already did.
We're just so excited. We're just so excited to adopt this draft opinion. I can't wait for a second. Thank you very much. I found that one very interesting.
So nuanced.
All right, the next opinion is file 2811, which was continued from the January meeting to allow staff to consider an additional legal issue in the draft and bring it back before us. All right, Mr. Herron, are you here for the requester?
I am the requester.
Oh, you are the
and I'm here
requester.
on behalf of the person I'm requesting it for.
This is very meta of you
Request of the
today.
requester. Okay.
Okay, are there any members who need to make a disclosure? I suspect not. Steve, go ahead.
Thank you, Madam Chair. Commissioners, this opinion request comes to us from Mark Herron, who asks on behalf of his client, who is a public employee who files Form 1, whether and how he must disclose his beneficial interest in a particular trust that has a spendthrift clause on his financial disclosure form. At the December meeting, you'll recall that we discussed the disclosure of a very complicated trust on Form 6. We issued that opinion in December for Commissioner Laird Lyle, and it is now serialized as CEO 23-8. We received the opinion request before you right now before CEO 23-8 was issued. So the requester made his inquiry without the benefit of having the Commission's most recent formal opinion on trusts. The draft opinion before you confirms that many of the sections of Form 1, on Form 1, the concepts outlined in 23-8 will apply to those pertaining to trusts with spendthrift clauses. We went over a lot of that last time about how a spendthrift clause will affect a trust, and I can go over that again if you would like, but The part of that opinion that is most relevant here is that you opined that a beneficial interest in a trust with a spendthrift clause is not an asset that must be disclosed in the assets section of Form 6, because it is not an interest that can be alienated or encumbered. Put another way, you opined that a beneficial interest has no value because that beneficial interest has no value because it cannot be sold on the open market and by operation of that spendthrift clause, and therefore would not be required to be disclosed. What makes this opinion a little bit different, or this opinion request a little bit different, is that this is a request for Form 1 and not Form 6. We often talk about how Form 1 is the less stringent version of Form 6, and that shorthand description is accurate in most contexts. But sometimes, like in today's opinion and the way that today's opinion request will demonstrate, it's obvious that there are different forms asking for slightly different information. This opinion request is also different because CEO 23-8, in that opinion, the requester, it's different than 23-8 because the requester here informs us that the financial disclosure filer at issue does not know what is in the trust. So he does not know whether there is anything that needs to be disclosed in the real property section or in the section for interest in specified businesses. Those sections of the form require, those sections of Form 1, rather, require that the financial disclosure filers disclose direct and indirect interests. That's different than Form 6 and on the other sections of Form 1, which require the disclosure only of direct interests. An indirectly owned interest is defined in the Code of Ethics as an interest in which legal title is held by another as a trustee or other representative capacity, but the equitable or beneficial interest is held by the person required to file a financial disclosure form. In the real property section of Form 1, filers are asked to disclose all property owned in Florida where they directly or indirectly have an ownership or beneficial interest exceeding 5%. In the interest in specified businesses section of Form 1, filers are asked to disclose businesses in certain industries where they have an ownership or beneficial interest in the business exceeding 5%. The draft opinion today stands on two principles. First, it communicates to the requester that he will have to disclose any beneficial interest in real property or specified business owned by the trust because those qualify as indirectly owned interests. To that end, the draft communicates that the presence of the spendthrift clause in the trust is not relevant to the question of whether the financial disclosure filer has more than 5% beneficial interest in the real property or in the specified businesses. While the spendthrift clause might render the value of those interests zero because they cannot be sold, it does not reduce the percentage of his beneficial interest. And all Form 1 is asking is whether the percentage of the direct or indirect ownership or beneficial interest exceeds 5%. Second, the draft opinion communicates to the financial disclosure filer that even though he doesn't know what's in the trust, he has an implied obligation to ask and to find out. The goals of financial disclosure cannot be met if we do not require that reporting individuals review all accessible information about their finances to inform their disclosures. The draft opinion goes into more depth on this, but basically the Florida Trust Code gives trust beneficiaries the legal right to ask the trustee of a trust what the contents of the trust is. That right can be waived, but the waiver can be revoked. The financial disclosure filer here has not yet executed a waiver, but he is advised not to do so as to preserve his access to the trust information when it becomes time for him to file his financial disclosure form. I present this draft opinion for your consideration, and I'm available to answer any questions you may have about it. As you already heard, Mr. Herron is also here to answer any questions on behalf of his client.
Go ahead.
It just feels low.
He's technically challenged.
Probably thought I was going to go up there.
Thanks for the presentation, Steve. Will this individual be required to, will he be covered by the new Form 6 law?
No, he won't be. He is a, my understanding is he's a specified state employee. The people that are switching over to Form 6 are the local, they are the elected municipal officers and mayors, and then the 9 people seated at this body.
Follow-up question, Madam Chair. So this is, I remember the other recommendation, it was a member that was of this body, and I had the same question. So it's income, but it's not income. I guess was what the question I had on that one, because it was in a trust that generated income, but he wasn't getting any income, but he was part of the trust.
Yeah, I remember the question, and what was going on there was we had facts in play for that opinion where we knew the trust was gaining income, because that, if you'll recall, that part of that question was about he's paying the income taxes earned on the income on behalf of the trust. We don't have any of that here. The trust might be earning income. We don't have any facts in play that this is an intentionally defective grantor trust. He's not the grantor of it in the first place. And I think maybe that's one of the differences too. The trust where the taxes were being paid, the requester was the grantor on it. This is a beneficiary. This beneficiary is not operating the trust, has not put the corpus of the trust into the trust. He doesn't control what's in it, how it's operated, how it's run. He will eventually benefit from the trust, I believe at the demise of the grantor, but this is not his money, it's not his income. He is not receiving disbursements, that we have that in the facts. So on the income side of this, it's pretty clear that the trust income is the trust's, that the trust is a legal entity, a separate legal entity that pays its own taxes. It's not his income.
One last question, Madam Chair. The statement of, I don't know what's in it, is that valid?
I worry deeply about, if we were to issue an opinion that says, I don't know a particular aspect of my finances, so I can't disclose it. For example, I don't know if I am or am not on the deed, or if I'm on the mortgage of the house, and I didn't look, so therefore I couldn't disclose it. Those types of things, I think, one of the things that they're doing in this state is they're making students take financial education courses, because the people are not necessarily up on what their finances look like and how those things work. And so what we're saying here is you need to look in order to afford the public the right to the information that they're allowed to get. It also, financial disclosure puts the public officer on notice of what their own conflicts are too. This is an annual reminder of what they have and what their conflicts might be and what issues to be careful of. There's not anything in this opinion request that indicates that this is willful ignorance or anything like that. But we are requiring, in this opinion request, we're requiring the the financial disclosure filer to go and seek out the information, because it's easy to get. All he has to do is, at this point, because he hasn't made a waiver, all he has to do is ask the trustee for the accounting information. Yeah,
I appreciate him asking for the opinion or getting the opinion, because that keeps him out of harm's way and keeps him from coming in front of us. And I think to do that, you need information, so you have to be informed about what's in it. So, thank you.
May I ask, I think I know the answer to the question, I'd just like to hear it out loud. When the question is asked by the filer, I am a filer, dear trustee, I am making a reasonable inquiry as to the contents of the trust. And the trustee says, dear filer, thank you for your inquiry. I look forward to working with you in the future. Sincerely, the trustee.
Right.
That's how that goes, right? I mean, possible,
It could,
more than likely.
Yeah, we obviously we don't have any facts like that in play. I think.
Well, we'll never know. I mean, so what we're
Right.
requiring, which I understand based on your answer to the previous question, that you don't want to just not say anything. So therefore, we'll say you make a reasonable inquiry, which is the way that I just expressed it, and that's all one can do. And you get the answer that says, I like you, but I'm not going to tell you.
Right.
Because part of my job is to protect, the beneficiaries of this trust. So, I mean, I'm just pointing out perhaps the obvious that it's an exercise in futility and appearances. So we're really not accomplishing anything meaningful by the inquiry. I understand the reason for it, but I'm sure Mr. Herron might be able to elaborate.
Yeah, there is a legal requirement that the trustee do disclose if it hasn't been waived. I understand that there are realities in play where maybe that doesn't quite happen. But, you know, it would be much akin, though, to if you need to figure out how much money is in your bank account, you go and you ask your bank, and the bank doesn't tell you. You have a legal right to that information. You know, I think that from the opinion side of this, there's only so much that we can write in a draft opinion on that. So I feel like we covered it to the extent that we could.
Are there any other questions for Mr. Zolkowski? Thank you. Mr. Herron?
Madam Chair, members of the commission, first I want to thank the staff, Steve, for all the time he's put in on this, both for the original draft as well as the revised draft. Trust law is numbing to my brain. That's why I don't do it for the most part. And I don't do it, I shouldn't say for the most part, I don't do it. So I want to thank him for that. My client is very satisfied with the opinion. In fact, the issue about the ask was the issue that stopped the opinion the last time we were here. That's why we rescheduled it for this time. He's very grateful that the language is in there that he has a duty to ask the trustee. Perhaps that will move the trustee to let him comply with the requirements of the law. We will only know what happens in the future. So we would ask you to adopt the draft opinion so that my client could have guidance as to how to act moving forward. Thank you.
Does anyone have questions for Mr. Herron?
Just real quick, Kwame, just like you, trust stuff just numbs my brain. And I never thought that by being a part of the commission, I would know more about trusts in the last 3 meetings than I did in law school. But it's an experience. No, but
Well, as our general counsel said, the first time I think the 22-8 came up was that this commission doesn't deal with opinions dealing with trust very often. Unfortunately, you've gotten 2 in the 3 meetings. Yep. Thank you.
Yeah, and I want to expend the same courtesy to you, Mr. Herron. I think it's good when people get opinions before they run a file, because normally they're in here when someone files a complaint and we're trying to unwind this in the process of finding probable cause, and it's a nightmare. Just getting an opinion, because only imagine if he had a problem and he was standing there and we tried to figure out, is it a trust, isn't it a trust, is it getting income, does he know what's in it, and of course, saying that you don't know, ignorance is not a good defense, as we know. So, but I thank you for seeking the opinion before that, so that keeps you out of harm's way.
Kudos to my client. Thank you, sir.
Was there a motion?
I move the adoption of the advisory opinion.
Second?
second.
All in favor?
Aye.
Thank you very much.
Moving right along.
Moving on to item number 9, consideration of financial disclosure appeals. Item number 1 is the consideration of, or I guess 9A, not 1, 9A, is the consideration of appeal of the automatic fine assessed for the failure of Joseph Ayano, case number 19-064, to timely file an annual disclosure form. Is appellant or their counsel in attendance? No. No, okay. All right, Mr. Burns?
Thank you. Good morning.
Oh, actually, does anyone need to make a disclosure? Assume not, but, okay, go ahead.
So this is financial disclosure appeal number 19-064 for Mr. Joseph Ayano. He was an assistant secretary with the City Place Community Development District, and he filed his 2018 Form 1 late in August of 2021. In this case, we had certified mailing sent to the address that was on file, which was returned as undeliverable. In his explanation, he wrote that the mailings were being sent to the address of his former employer, and as soon as he got notice at his correct address, he did file his form shortly thereafter. Given that we have no evidence to dispute appellant's claim that he did not receive any notice, that constitutes unusual circumstances which justifies waiving the fine under section 112.3145 8F. I'm available for any questions.
Any questions? Motion to adopt the final order.
So moved.
Second.
All in favor?
Aye.
Thank you. All right, the next one is the financial disclosure appeal for Leroy Collins III, case number 19-079. Is the appellant or counsel in attendance for this one? No? Okay, go ahead, Ms. Hayward, thank you.
Thank you, Madam Chair. This pertains to financial disclosure appeal FD 19-079 relating to Leroy Collins III. The appellant served as a member of the Board of Supervisors of the Dog Island Conservation District, a position that requires the filing of a CE Form 1. This appeal pertains to his failure to timely file his 2018 CE Form 1, for which he incurred a $1,500 fine. As you can see in your meeting materials, many notices concerning his obligation to file his 2018 CE Form 1 were sent to him both by the Commission and by the Hillsborough County Supervisor of Elections. They were sent to an old address, however, and the appellant contends that he didn't receive the notices, which included the notice of his appeal rights. When Commission staff spoke to him on November 12, 2021, they updated his address and sent him another notice of assessment of automatic fine, which included his appeal rights, sent him an appeal form, and a 2018 CE Form 1. The notice stated that the appellant's appeal would have to be received by December 13th, 2021 in order to be considered timely, and on December 13th, 2021, the Commission received his appeal of automatic fine for form year 2018 and his 2018 CE Form 1. The basis of the appellant's appeal is that he never got notice of his reporting requirement because the notices were sent to his previous address. He states he had not lived at that address since 2015 and that he sold the property in 2017. Even though the appeal is untimely, I recommend that you treat it as timely, given the fact that the notices, including the notice of his appellate rights, were sent to an outdated address. The appellant says he never received them, and we have no evidence to dispute this. Further, when he received notice of his appeal rights and his obligation to file, he submitted the appeal and his CE form to the Commission in a timely manner. With regard to the $1,500 fine, the statute regarding financial disclosure says you have the ability to affirm the fine, waive the fine, or reduce the fine. To reduce or waive the fine, there must be a finding that there were unusual circumstances over which the reporting individual had no control, as well as a finding that those circumstances directly resulted in the appellate's failure to act in accordance with the filing requirements. The Commission has found lack of notice to be a legitimate reason for finding that there were unusual circumstances that prevented an appellant from filing their financial disclosure form. Due to the facts that postal records in the file indicate that the notice of assessment of automatic fine the Commission sent to the appellant at his old address was returned due to a problem with the address. The appellant states he moved from the location we were sending the notices to in 2015 and that he never received them, and there's no evidence to dispute this. I recommend you find there to have been unusual circumstances that prevented him from filing his financial disclosure form, and that you rescind the default final order issued in the case and waive the $1,500 fine. Thank you.
Thank you. Are there any questions? Is there a motion to adopt the final order rescinding the fine?
So moved.
Second.
All in favor?
Aye.
Thank you very much. All right, the next set of financial disclosure appeals, there was no hearing requested. This is item 9 on the agenda. These are also appeals of automatic fines for failure to timely file the annual disclosure form. Number 10, under item 9, has been administratively continued to the April meeting because we do not have enough members present at this meeting to have a quorum for that appeal. And so we'll take up appeals 1 through 9 under item 9. The listed appellants did not request to be heard, so there'll be no oral presentation unless a member requests it. So for appeals 1 through 9, are there any appeals a member wants to set aside for presentation by staff to take up separately? Or does anyone have a disclosure to make? Are there any questions on any of these items 1 through 9 from the members?
So I got Iris Gomez out of St. Pete. I know her, so, but it won't affect my decision on this case. Number 3, Iris Gonzalez.
Would you like that item taken up separately? Or can
No,
we vote on all?
No, I'm just disclosing that I do know her, but it won't affect my decision.
Any other disclosures or questions? And if not, if there's a motion for, to adopt the final orders for items 1 through 9.
I move the approval of the orders recommended for items 1 through 9.
Is there a second?
Second.
All in favor?
Aye.
Item number 10. Oh, this is a financial disclosure fine case where after the final order imposing the fine, it's been recommended that we declare the fine uncollectible because the filer has passed away. Are there any questions from the members on this, or does anyone have a motion?
How are we gonna get our money? No, I'm just kidding.
Oh my gosh.
It was too easy.
I move the approval of the recommended order.
Second.
Good. All right, all in favor? Aye.
Aye.
That's the way the IRS does it.
Okay, on to rulemaking. So we have a rule hearing today that was originally scheduled for our January meeting, but it was tabled in consideration, or we tabled consideration of the matter until today's meeting. Thank you, Vice Chair, for spearheading that effort. The purpose of a public hearing is to allow the commission, I would have rather been here, to hear public comment, evidence, and argument about the proposed rule or proposed changes to an existing rule. Following the public hearing, the commission will decide whether to make any changes in response to public comments or written materials received, or whether to accept the rule as noticed. The commission may withdraw a rule in whole or in part, or may make such changes that are supported by the record of the public hearing or any written materials we have received. The commission may also make technical changes which do not affect the substance of the rule. I'll ask Mr. Schaefer, who prepared the draft items, to explain the rule changes and put us in the proper posture, and then we'll proceed with the public hearing, deliberation, and vote.
Thank you, Chair. Commissioners, this particular series of rule amendments all pertain to rules in Chapter 34-8 of the Florida Administrative Code. And as you know, that rule chapter, among other things, sets out and incorporates by reference the Commission's various financial disclosure forms and the instructions for completing them. There's 2 areas of rulemaking here that need to be addressed this morning. Both of these areas were discussed in a rule hearing, as you heard the Chair say, held back in January. At that time, the Commissioners at the January meeting voted to table the rulemaking in these areas to have them represented now this morning. Because the specific rule changes that we're proposing were covered in detail back in January, and because they're discussed extensively in the materials in front of you, I'm not going to go into too much detail on the specific changes that we're proposing. Instead, I just want to clarify some points that were emphasized during that previous rule hearing in January and talk to you about some things that have happened since then, because this has actually been a very active area that may influence your decision-making this morning. The first of the 2 areas of rulemaking is the one that triggered the most amount of discussion in January. It's a proposal to amend the income disclosure requirements for the Form 6. Those requirements are laid out in our income rule for the Form 6, which is a particular rule in Chapter 34-8. They're also found in the instructions for completing the Form 6, and those instructions are incorporated by reference in different rules in Chapter 34-8. Now, the amendment that we're proposing is to allow attorneys who might have a client exceeding the income disclosure thresholds to just write legal client on their Form 6 filing in the income portion without specifically identifying that client. And this change is being proposed to make sure that filers who are attorneys will not be in violation of Florida Bar Rule 4-1.6a. Now, that Florida Bar Rule is called the confidentiality rule. It says that attorneys, and this is a quote, must not reveal information related to a client's representation. Now, as we went over at the January hearing, the Florida Bar issued an ethics opinion way back in 1977, indicating that the confidentiality rule, which we're talking about this morning, would be triggered if an attorney who's a public officer identifies a legal client as a source of income on their financial disclosure filing. So we're trying to avoid a situation here where an attorney will be caught between a rock and a hard place, where they'll have to make the decision of whether or not they want to violate our disclosure requirements by withholding their client's identity or violate the bar rule by identifying their client on their form. Now, there's a few things I want to emphasize about this area of rulemaking. These are all laid out in the memo and your meeting materials. The first is, I think it's worth noting that instances where attorneys may find themselves in this predicament may be fairly rare. Most instances, I think this is going to arise when they're completing the secondary sources portion of their Form 6 filing. Now, this is a simplification, but in that section, attorneys have to disclose clients of their law firm who make up a significant part of their firm's annual income. In particular, example is any client making up over 10% of their firm's gross income during the fiscal year. Those clients are considered to be secondary sources of the firm's income and have to be identified on the form under our current version of the income disclosure requirements. So I just want to emphasize this is not a situation though where each and every client of a law firm will need to be listed, but only those clients making up over 10% of the firm's income. So this rule change will only affect those particular clients. Now, that all being said, this could arise, and Commissioner Lyle back in December brought an opinion request about this because he had, if you remember, kind of a more boutique firm with just a few clients a year, and he felt very well that this situation could arise for him. So following the January rule hearing, we reached out to the Florida Bar to confirm that they still believe that former opinion they issued back in 1977 is still valid today, that attorneys would be in violation of the confidentiality rule if they identify a client on a disclosure filing. We received a written response from the Florida Bar. It's in your meeting materials. And their response, they confirmed our understanding that that 1977 opinion is still their interpretation of the confidentiality rule, that attorneys would be in violation of that rule if they disclose their client's identity on the form. Now, they also clarified a few other things. They wanted to emphasize to us that confidentiality rule goes deeper and further than attorney-client privilege, which is a general concept most people have heard about. Attorney-client privilege is a concept found in the Florida Evidence Code. This is, again, a kind of a simplification, but it protects the confidentiality of communications between an attorney and a client during the course of a legal representation. But attorney-client privilege goes just to those communications. It doesn't shield an attorney from protecting the identity of their client. So the Bar wrote to us, so the confidentiality rule, which is what we're really concerned about today, is much broader than attorney-client privilege. And again, it would be triggered if a lawyer writes down the identity of their client on a Form 6 filing. That's the Bar's interpretation of this rule. I also asked the Bar to respond to something that Commissioner Newton raised during the January meeting, which was whether or not we could just ask attorneys, instead of disclosing a client's identity, just to write down the amount of money paid by the client to the firm, whether in a monetary percentage or in some type of dollar figure. Whether in a monetary amount or some type of percentage figure. The Bar wrote back to us that they still believe that would violate the confidentiality rule because it's information related to the representation of a client and it might lead to the discovery of a client's identity. But the Bar did write to us that they agree that just listing legal client alone, which is what we're proposing, would not trigger a violation of the rule. Now, the next thing I want to point out that's happened since January is that the legislature has also recognized the inherent conflict in an attorney revealing the identity of a legal client on their disclosure filing. Following the January meeting, the Senate amended its proposed ethics bill, that's Senate Bill 7014, to include in the Form 6 and the Form 1 statutes the exact same language that we're proposing to you this morning. allowing an attorney to write legal client in the disclosure fields without providing any further identifying information. That version of the bill passed unanimously in the Senate, and yesterday it passed in the House as well. So my understanding is that it's now going to be on its way for the governor's consideration. You may wonder then why we even still need to do rulemaking on this. My answer is that even if the bill becomes law, it may take some time for that to happen. We don't know exactly when it's going to be passed off to the governor. We don't know exactly how long it's going to take the governor to sign it into law. So we are heading into a very busy season regarding disclosure filing. We're heading into the summer, and most people are more concerned about filing their disclosure forms. This allows us to clearly give advice to attorneys, like former Commissioner Lyle, that may call in with questions about this. It's almost a stopgap to provide coverage to us to know how to clearly answer these questions until this new law goes into effect. Now, obviously, transparency is a very important issue in government. It's really the whole reason for financial disclosure. I think the commissioners at the last meeting were very concerned about compromising that transparency in any way by engaging in this rulemaking. But I think it's important to note that your legal staff, the staff of the Florida Bar, and now the Florida Legislature all agree this change is necessary. And I think that the fact that they approved this particular bill is an endorsement of the language that we've asked you to consider. Now, I don't want to beat a dead horse here. There are a few other things I do want to emphasize about this area of rulemaking. The first is the Commission by law only has authority to pass rules about disclosure that are not inconsistent with the law. That says it right on our delegation of rulemaking authority in the Code of Ethics. We can pass rules regarding income disclosure on a financial disclosure form or any other area of the ethics laws as long as it doesn't place a final violation of another legal requirement. Now, unless we amend this rulemaking today to put in this provision about attorneys, that situation could very well occur because an attorney filling out a Form 6, if they follow our income disclosure requirements to the letter, could very well be in violation of the bar rule if they go ahead and disclose their client's identity. The last thing I want to note about this area of rulemaking is something that I know Commissioner Anker said resonated with her during the last hearing. If we don't pass this rule, it's going to place a lot of attorneys in a very sticky predicament. Many attorneys may not know if a client crosses that 10% threshold for the bottom line of their firm until well after the representation is underway, or maybe even after the representation is already concluded and their firm is balancing the books in the following fiscal year. If the attorney at that point has to ask that client for consent to list the client's name and the client refuses, we're going to be faced with that rock and a hard place, no one scenario for that attorney. If they go ahead and list the client's name on their Form 6 against the client's wishes, they'll be in violation of the bar's confidentiality rule. If they withhold the client's name, they'll be in violation of our disclosure requirements. So that's exactly what we're trying to prevent here by encouraging you to adopt this rulemaking. Now, that all being said, that is just the first area of rulemaking in front of you this morning. I don't want to forget the other area of rulemaking, which unfortunately or not has kind of been lumped in and noticed with this attorney piece of the puzzle. The second area of rulemaking has nothing to do with attorneys, has nothing to do with the bar rule. We're just requesting you amend the disclosure form instructions to remove any reference in the training certification section to independent special district officers. That section where they have to report the fact that they got 4 hours of training is not going to be applicable to them until they complete their 2024 disclosure filings, which won't be until next year in 2025. It was premature to mention them in the training certification portion of the instructions. We just want to temporarily remove them, the reference to them in that portion of the instructions. We'll be adding them back in later on this year when we clarify our instructions for the 2024 disclosure filings that they'll be completing next year. If you have any questions about either area of rulemaking, let me know and I'll be happy to answer them. I will say all these amendments have been noticed in the Florida Administrative Register. All this language has been provided to JAPC. I checked yesterday, JAPC had no feedback for us, which I take it to mean that they feel that we are not acting beyond the boundaries here of our delegated rulemaking authority. So I submit these changes to you now. I'm happy to answer your questions.
I have a comment, not a question. Well, I want to thank you for first and foremost for doing the heavy lifting on this. Why I don't agree with the dollar amount being put on a financial disclosure form and just a statement. I do have some comfort in knowing that the Senate and the House, I was over there last night at 10 o'clock at night with them, are already working on this, and it's up to the governor. My only concern, and I guess the question would, how would that affect us if the governor vetoes it?
If the governor vetoes the
Yeah,
bill?
we do what we're doing now, and then it doesn't happen. You know what I'm saying? We're just trying to preempt, well, that's a bad word. We're just trying to give them some cover for the financial disclosure season. But if the bill doesn't make it through the governor, then it's back where we were.
My response to that is I still believe, and when I presented this to you all in January, we didn't know that that language was going to go into Senate Bill 7014 yet. This is regarding the attorney piece of the puzzle, and I want to make it clear, there's two areas of rulemaking here. I don't want to forget about that training certification portion, but I think you're just focused on the attorney piece of the puzzle. That just concerns adding that language to the Form 6. Even if this bill hadn't been proposed in the legislature, I still think we have the authority to do this regarding the Form 6. The Constitution gives us the authority to pass rules regarding the disclosure of secondary sources of income on a Form 6, which is exactly what we're doing. So even if the governor vetoes the bill, I still think that we are acting within the boundaries of our rulemaking authority here when it comes to the Form 6.
Again, like I said, I have some confidence knowing that the legislature was working on what we don't want to do, and what I'm suggesting that we don't do, even though we have that rulemaking authority, is run afoul with the legislature as we're making laws up here as it pertains to financial disclosures. While you may have the authority, I don't think that shines brightly on the people actually making the statutes and the laws. But you say they're both in agreement, and they did pass that off the floor last night, so I'm okay with that. I'm okay with that, because that means that they're working on it and we're not, overstepping or doing something that they're not already see as a problem. So I'm okay with that. I'm just, just the what ifs. I mean, these things still have to go to the governor's desk. They have to be either signed or vetoed or let become law without a signature. So there's three options, but I don't know what's going to happen.
If I may, through the chair, I just to respond to that, Commissioner Newton, I don't know if this will give any comfort at all, but the Joint Administrative Procedures Committee, JAPC, their job is to review all of the rules that every state agency proposes to make sure that the agency is acting within the boundaries of their delegated rulemaking authority. If JAPC felt that we were coloring outside the boundaries of that, they would have shut down this rulemaking and let us know. So the fact that JAPC, even before the Senate bill was proposed, did not have any questions or concerns about this area of rulemaking, I think lends support to what I'm saying, which is that in terms of the Form 6, I think we have the authority to do this on our own, to engage in rulemaking.
What has transpired is that in the separation of powers, the executive branch, the judicial, and then the legislature, we have the judicial interpreting what we send to them after the governor signs it into law. But what has happened is because of some of the ambiguity, they try to, make up the law as they go along from the bench, and that ran afoul with the legislature. I was there personally with my Speaker Corker, when that transpired, and it was not good. Even though they had the authority, it was not good. So that's all. That's why I was going from experience, not from the what ifs. I was there, and I know that we have that authority. But like I said, it brings me comfort knowing that the legislature branch have already acted on this, and they're waiting on the executive branch. So thank you.
Are there any members of the public here that wish to be heard on this rule? Are there any other comments or questions from the members on the draft rule, either of the two parts of the draft rule that Mr. Schaefer presented?
Make a motion if you'd like, please do. I move that we approve the proposed amendments for rulemaking.
Second.
All in favor?
Aye.
Thank you very much.
Good job.
Alrighty, item number 12 relates to commission expenditures for recently filed litigation, one case in federal court and one case in state court. So I'll recognize Ms. Stillman to present that.
Thank you. Thank you, Madam Chair. No, I need to pull this microphone to me. We have to share. Briefly, Commissioners, you know I have limited expenditure authority. You also know that there has been another couple of lawsuits filed involving the Form 6. As such, the Attorney General's office will be representing us in that litigation, not our advocates, but through a different contract. And I need your approval to make expenditures to pay for those invoices. I expect they will exceed my expenditure authority of $10,000. We do have money in the budget left under the litigation category. I think we have about $31,000 left in there. So I would also ask that if the attorney's fees and costs exceed the amount that we have left in that budget item, that you approve that I be able to ask for the use of carry forward funds to cover any overage for the remainder of this fiscal year. I have sought an estimate from the Attorney General's office as to how much they think it might cost for the remainder of this fiscal year, and I don't yet have that estimate in hand. I just sought that recently. I should have it soon, but I ask that that you all approve my ability to pay for these legal services using the money in the budget and then seeking carry forward if we exceed it. Thank you.
I have a quick question. Would we have the ability, if we wanted to see the invoices periodically?
Yeah. Thank you, Chair. We do see those invoices. They come into the office. Steve and I review the invoices that we receive from the Attorney General's office, and they're noted in segments of time.
Oh, I mean the numbers.
Certainly.
If we ever wanted to request, could we just take a look?
Yes, if that's something you wanted me to provide, I could provide it as a part of the ED report on an ongoing basis, or if there's a particular request at a particular time, I can include them then, whatever you all would like.
Are there any questions related to Ms. Stillman's request for expenditures?
Madam Chair?
Oh, yeah,
If
sure.
I may,
Sorry about that.
two things. Carrie, I think you said 31,000, and the memo says 41,000.
Through the chair, there was an allotment for 41,000, but we have already spent through other
Okay,
litigation on the Amendment 12 litigation. We have spent some of those funds before it flipped over.
And the second thing with the invoices, if we do that as part of commission materials, I'd have to check, but my gut instinct is that that would have to be part of the public materials. I'd have to check to make sure that that's not, we had this discussion about a year ago on something else. I would have to look, but that's something, if we did it in a meeting, it might have to be in the public materials.
Okay. Thank you.
Madam Chair, I move the approval of the request to spend funds from the budgeted funds and in the carry forward funds for this litigation.
Second.
All in favor?
Aye.
Thank you. And right back to you for the executive director's report.
Okay, Madam Chair, I don't have anything to add to my written report for the Executive Director's report. I can go ahead and proceed with legislation and e-filing if you would like. Okay, let's begin with our legislative report. There were a couple of bills in particular we have been tracking and have been somewhat active on. I'll start with the easiest first. House Bill 735 and Senate Bill 734 that would have had the effect of the commission implementing local lobbyist registration. I don't like to make predictions involving what the legislature might do, but 734 still had one committee meeting to go through in the Senate. 735 was on third reading and was temporarily postponed. So it would not appear that those bills would make it through the process at this point in time, but the legislature has not yet adjourned, so, but that is the current status of those. The big one on the menu is Senate Bill 7014. This bill has passed the legislature after being amended in both chambers. It did contain a couple of your legislative recommendations, including raising the penalties for in-office and post-office lobbying restrictions to $20,000, so that those civil penalties matched the other civil penalties that were raised last year, and also allowing candidates seeking office to seek costs and attorney's fees if they meet the requirements of law. That was another recommendation you made. That is in the bill, and that becomes effective upon the bill becoming law. Also effective upon becoming law is the change in the commission members, what I would call term limits. The bill changes the limitations from 2 full-year terms in succession to 2 terms, period. So members used to be able to go off the commission and be appointed again. Under this bill, once you've done your 4 years total, you would not be able to be appointed to serve again later. Also, as Gray mentioned, the language from rulemaking that was put forth in January that you just considered and passed today was also made a part of this bill. I'll note that the language that you considered in January for rulemaking was not in the bill at that time, as Gray mentioned. After we did not adopt the language at the January meeting, that language then appeared in an amended version of the bill. That becomes effective in the law once the bill is signed into law. Also becoming effective upon becoming law is the amended version of the bill that included a requirement that complaints filed with the commission must be based on personal knowledge or information other than hearsay, as well as some amended language relating to local ethics commission. That language was not heard in a committee. It was part of an amendment on the floor. It's a new requirement that will become effective upon becoming law. This standard marks a significant shift in the requirements of complaints filed with our agency, and without a doubt, it will have an impact on complaint proceedings. The extent to which the new standard will actually impact the complaints and the work that comes before this commission will be known in the fullness of time, and that becomes effective as soon as it is signed into law. I have no reason to think that this bill will not be signed into law. A significant portion of the bill relates to timeframes for our complaint processes. We were thankful to be a part of that discussion in the beginning to get those timeframes to something we thought that we might be able to accomplish, and those timeframes become effective October 1st of 2024. I think we can be successful with this. We've asked for and will ask for additional funds to potentially augment staff so that we can be successful with the implementation of this bill. As we work towards fully implementing electronic filing, we're also going to be working to begin to implement the requirements regarding the timeframes and the personal knowledge or information other than hearsay. We're going to reimagine our workflows and our office processes. Our current database doesn't contemplate the kind of tracking. It's simply a database. It's not a case management system. So we're going to try to put some things in place before October with the timeframes to be able to implement this bill and try to get rolling out it a little early in a lot of aspects. One of the other things that will become effective in October is language relating to the voting requirements to change a recommendation of the advocate. In the version that we talked about at the last meeting, the requirement was 6 members of the commission to divert or reject an advocate's recommendation. You asked that the chair let leadership know in the House and Senate that you were opposed to that particular language in the bill. I believe your concerns were heard in the bill that ultimately passed both the Senate and the House, this concept changed to where there is a 2/3 vote requirement of the members in attendance at a meeting to reject a stipulation. That is a very different thing than rejection or diversion from an advocate's recommendation in a closed session meeting. So once this takes effect, when there are stipulations before the commission that have either been mediated at DOA or just negotiated by our capable advocates, if you are unhappy with that stipulation, it will require a vote of 2/3 of you to reject that and send them back to the drawing board. So with that, we have quite a bit of rulemaking ahead of us to implement the significant legislation that I anticipate will become law. So we will have ample opportunity to discuss the ins and outs of the new statutory language as we work through that rulemaking process. And with that, it concludes my remarks unless there are questions.
Yes, a question. The first one is, what percentage of our complaints, I guess, that we received in the offices were hearsay?
Through the chair? That is not something that we have previously tracked. We were only reviewing the cases in relation to the law as it currently exists. So that wasn't a metric that we would know.
Well, the law now is, well, the law that's heading up to the governor is firsthand knowledge. That's why I asked that, how much was hearsay? Just a question, because, I mean, if it wasn't firsthand knowledge, it was hearsay. It was stuff that people heard or thought, and it triggered a complaint. That's why I asked that. My other one is the 2/3. That's just the majority. We was already doing that. Am I correct when we have our voting up here? As far as rejecting or accepting an advocate's recommendation? Through
the chair, it was a simple majority. I think Steve checked me on this, but for 9 members, I believe it would be 6.
Yes.
For 8, it would be 5.
That's right. So fractions-wise, instead of being 3 out of 2/3 is going to be more than 50% plus 1 in some instances. So at 9 members, we need 6. At 8, we need 5. At 7, I think we need 5. So if there were 7 members here, normally we'd need 4. So it's a little bit of a steeper bar to reject a stipulation, but that's been the policy choice that's been made.
Are there any other questions? I just wanted to make 2 quick remarks on this, and that is that the staff, there's a lot of changes that came from these bills, and staff is going to have their work cut out for them. So please, keep us updated on implementation efforts, and if there's ever anything that we can do to help with that, and any action items for us or any advocacy that you need from us, please let us know. Also, on the change from diverting from the advocate's recommendations to just now it being limited to joint stipulations, I really hope, Ms. Miller and Ms. Hadley, that you, I wasn't here at the January 26th meeting, but I do hope that you were able to watch the remarks in the Senate committee when Carrie, Steve, and I went, because that position could not be less of a commentary on how well this commission is served by you 2 individuals. It's unrelated to that, and I tried to make that clear in my comments, and I know that that's the sentiment. I assume that's the sentiment of all of us. So thank you for your work. Thank you for the update, Carrie.
May I ask one question that probably didn't change as a result of the term limits now for commissioners, but if a reappointment is not made and someone is essentially left to be a squatter, that wouldn't violate the law. You're still just here until they appoint a replacement, even in spite of the term limit. Is that correct?
The way the law is currently written, a member continues to serve until they either resign or get reappointed. Under the new language in the law, that may be a different story.
Not sure. Is that what you're telling me?
We're researching that.
Okay. We can make it easy on them by resigning, but to try to honor the system, both their goal of having term limits but also, you know, have enough people to serve as a quorum is important, and that's why I raised it out loud.
That's what I was gonna ask. I was gonna say, note the quorum. We got that problem now. You can't, if one of us leaves, we got to stop. Because you don't have a quorum. So I'm just saying, if they put it that way, she's exactly right. Person has to leave. Now, if they don't pick somebody real quick, then you can't even meet, because you can't do business, you can't vote on anything. So hopefully they consider that.
And last question, you may have said this, the effective date of the new package is July?
The parts related to the timeframes become effective October 1. Other parts of the bill become effective upon the signature.
Thank you.
Okay. Moving on to e-filing, we are continuing with our e-filing rollout. For Form 1s, it is, of course, live, as are the 6s, which they were last year. The total number of filers registered in EFDMS on or after January 1st, 2024 is 1,043. In January, it was 845, so the numbers are going up. There were also 242 non-incumbent, non-annual filer candidates registered new in 2024. So far, we've had 1,670 Form 1 disclosures. There were only 419 last time, so this includes also the 1X and the 1F being filed electronically. So it is happening. There have been 204 Form 6 disclosures, including the 6X and 6F filed so far in 2024, and that includes 107 city commissioner and mayors filing the Form 6 for the first time. So we have a total currently of 1,874 forms e-filed so far this year. Of those forms, about 44 of them had document uploads included with their forms. I say that because with each document upload, your staff has to review for redaction, so that's additional work with us now that those uploads were required to become a feature. Right now, we're continuing to solidify our list and our email addresses, which are so critical, provide enhancements, troubleshoot bugs to the system, which thankfully there haven't been many, and create some helpful publications and videos for filers. We're also, we've begun working with the folks at Alight on the call center for that contract expenditure that you had approved, getting ready to go with the upcoming financial disclosure season. They have already started to identify their resources who will be working with us on that, and we are marching forward confidently with a plan to make sure that when folks contact us and they have questions about their form, particularly with e-filing or questions about navigation, we are going to be ready for them. I anticipate by the time we have our April meeting, we will be well underway with the call center and invitations to register, and starting to see more and more people file their disclosure form. And we will be getting to state candidate qualifying period. It is an election year, so we will have that also. So also underway is the thing we are looking most forward to, and that is the requirement gathering for the fines and appeals that will finally get incorporated into the e-filing system. That will be the last piece to go in. And that is my report.
Thank you. Were there any questions on the e-filing report? Is there a motion to adjourn?
So moved.
Second?
Second.
All in favor?
Aye.
Thank you all very much.